you're in the right place. Because what is happening right now in cities like Los Angeles is unlike anything this immigration system has seen in modern times. And if you or someone you love is living in a major U.S. city, if you have a visa, a pending application, or you're waiting on any kind of immigration status, you need to watch this video all the way through. Not because we want to scare you, but because what we're about to break down changes the rules of the game entirely. There is a law. It was written in 1798. 1798. A law so old that the United States didn't even have a functioning Supreme Court building yet. And as of this week, reports confirmed on March 4, 2026, the current administration is actively attempting to use that law to remove people from cities like Los Angeles, bypassing the immigration court system that millions of immigrants have relied on to protect their rights. The American Immigration Lawyers Association has already issued a stark warning. They are calling this a direct threat to due process in America. So, let's talk about what that actually means for you. While social media is exploding with rumors, partial screenshots, and worst-case panic, we are looking at the official text. We are looking at the actual law, the actual legal warnings from professional associations, and the actual implications for real people living in real cities right now. Remember, I am an analyst guiding you through the system, but this is educational content, not legal advice. Always consult an immigration attorney for your specific case. That part is non-negotiable, and by the end of this video, I'm going to tell you exactly how to find one. Let's start at the beginning. Let's start with 1798. The Alien Enemies Act was passed by the Second Congress of the United States during a period of extreme political fear. America was in a Cold War with France. There was genuine panic that foreign nationals living on American soil were secretly working against the country. So Congress gave the president a dramatic, almost unlimited power. Under this law, the president can declare that nationals of a hostile foreign nation or any group deemed a threat to national security are enemy combatants. And once that declaration is made, those individuals can be detained and removed from the country without going through the normal immigration court process. Let that sink in for a moment. No immigration judge, no hearing where you can present your side, no opportunity for your attorney to challenge the evidence against you. Just a presidential declaration, and suddenly the legal protections that millions of immigrants have counted on, the very protections that made this country's immigration system different from authoritarian regimes, can be suspended. This law has only been used 3 times in American history: during the War of 1812, during World War I, and during World War II, which is the same legal framework that was used to justify Japanese-American internment camps. That is the historical company this law keeps. Now here is where it gets complicated, and I need you to stay with me here, because this is the part most people are getting wrong online. The administration is not simply announcing a mass deportation under this law the way some headlines are suggesting. What is happening is more legally nuanced, and in some ways more dangerous precisely because of that nuance. The argument being made is that certain groups and the language being used target specific nationalities and individuals linked to organizations the administration has designated as criminal or terrorist in nature fall under the category of alien enemies, as defined by the 1798 statute. If that legal argument holds, and this is a massive if, courts are currently fighting this, then those individuals could be removed on an expedited basis without the standard due process protections. The AILA, the American Immigration Lawyers Association, one of the most respected legal professional bodies in this country, has come out forcefully against this move. Their position is clear. Applying the Alien Enemies Act to immigration enforcement in peacetime, outside of a formally declared war, is an unprecedented and dangerous expansion of executive power. They are describing it as a potential death of due process within the immigration system. That is not social media panic. That is the professional judgment of thousands of licensed immigration attorneys across the country. And here's something most analysts are not talking about. The implications don't stop with the specific groups being targeted right now. When you create a legal precedent, when you successfully argue in a court that a 226-year-old War Powers Act can be used to bypass immigration courts, you have opened a door. And doors, once opened, are very difficult to close. The question that every immigrant in this country should be asking is not just, does this apply to me today? The question is, what does this precedent mean for my community tomorrow? Let's look at the facts, not the fear. Here is what we know with certainty. Courts are already pushing back. Multiple federal judges have issued orders questioning the constitutional basis for using this law in a peacetime domestic immigration context. The legal battle is very much alive, and the outcome is not decided. The due process protections you have today have not been formally eliminated by any court ruling. What is happening is a contest, a legal and constitutional fight happening in real time. Some of that fight is happening in Los Angeles. Some of it is happening in Washington, D.C. And the outcome of that fight will affect every single immigrant in this country. Here is what is not certain. We do not yet know how far the courts will allow this to go. We do not know how broadly the administration will attempt to define the affected groups, and we do not know how quickly enforcement actions will escalate in specific cities while these legal battles continue. That uncertainty is exactly why this moment demands action, not paralysis. Let me bring this down to a human level, because sometimes legal language makes us forget that we're talking about real lives. Think about a family in the Los Angeles area. Parents who came here years ago, built a life, have children who are American citizens, and have a pending immigration case in front of an immigration judge. Under the normal system, they have a court date. They have an attorney. They have the right to present their case. Under a scenario where the Alien Enemies Act is successfully applied and expanded, that court date may not matter. That hearing may not happen. The process they spent years navigating could be bypassed entirely. Their attorney could be notified after the fact, not before. That is not a hypothetical designed to frighten you. That is the scenario that immigration attorneys across California are actively preparing for right now. And if you are living in a major city, what attorneys and advocates are calling a blue city, a city with a larger immigrant population and a history of more limited local cooperation with federal immigration enforcement, you need to understand something. These cities are not immune. In fact, the intensity of federal enforcement attention in cities like Los Angeles, Chicago, New York, and Houston appears to be increasing, not decreasing. Being in a sanctuary city does not mean being invisible. It never did, but it is more important to understand that now than ever before. Stay with me, because the next part is the most important part of this entire video. Here are 3 things you can do right now, not next week. Right now. The first thing is to locate and organize every single immigration document you have. Your visa, your I-94 record, any approval notices, your passport, any receipts from USCIS, any correspondence from an immigration court. Put copies in multiple places. A physical folder at home, a digital scan on a secure cloud account, and a copy with a trusted family member or friend who is not in your household. If you are ever in a situation where you are approached by authorities, having immediate access to proof of your legal status is one of the most powerful tools you have. The second thing is to connect with an immigration attorney this week if you don't already have one. Not a notario, not someone who calls themselves an immigration consultant, a licensed immigration attorney. You can find one through the AILA website, that's AILA.org, or through your local legal aid organization. Many offer free consultations. Many work on sliding scale fees. If you are in Los Angeles specifically, organizations like the Coalition for Humane Immigrant Rights, known as CHIRLA, have legal resources available. Having an attorney on record before something happens is a completely different position than scrambling to find one after. The third thing is to know your constitutional rights, and make sure your family knows them too. Regardless of immigration status, all persons on U.S. soil retain certain constitutional protections. You have the right to remain silent. You are not required to sign any documents without first speaking to an attorney. You do not have to consent to a search of your home without a warrant signed by a judge. These rights exist right now. The legal battles we are discussing are about what happens in immigration court proceedings, not about your ability to exercise these fundamental rights in an encounter with authorities. Write those 3 things down, screenshot this part of the video, share it with someone who needs it. Because here is the truth about this moment. The American immigration system has always been complicated, imperfect, and deeply political. But what is happening right now, the attempt to invoke an 18th century wartime law to restructure how immigration enforcement works in the 21st century, is not business as usual. It is a shift, and shifts, if you are not watching carefully, can catch you completely off guard. The courts are fighting, attorneys are fighting, communities are organizing, and information is the foundation of all of it. The people who are most at risk right now are not the people who are paying attention. They are the people who are getting their news from a panicked voice note in a family group chat, from a Facebook post with no sources, from someone who heard something from someone who heard something else. That is what this channel exists to stop. Immigration policies in this country can shift overnight. A court ruling can come down on a Tuesday morning and change the landscape by Wednesday. A new enforcement memo can expand or restrict operations with almost no public notice. The only real protection against that kind of volatility is staying informed, staying organized, and staying connected to people who are reading the actual documents so you don't have to decode them alone. If this video gave you something useful, if it answered even one question that was keeping you up at night, please subscribe to this channel right now. Turn on your notifications, because the next update might be the one that directly affects your case, your family, or your community. And you deserve to hear it from a calm, verified, trustworthy source before you hear it anywhere else. Stay informed, stay documented, and take care of each other.